Day, which is always held in April. So this time of the year is traditionally for not for startups, that's the beginning of the year, for scale-ups, for businesses which have already succeeded. Now, that's one of the things we're celebrating today. But another thing is that the World Intellectual Property Organization, which is the world's which is the United Nations Agency for Intellectual Property, facilitates the obtaining of patents and trademarks and registered designs outside the boundaries of any single member state. They are celebrating World Examiners Day, World IP Examiners Day today, which basically means that they're celebrating the efforts of patent examiners, trademark examiners, design. Well, we don't have examination designs in this country, we do in those other countries. And to ensure that standards are kept, but to ensure that the technology are disseminated, which are covered by the inventions, are disseminated. That's the celebration today. Now, as our own intellectual property office, it is in Wales, we are going to be talking a little bit about how to apply for patents, trademarks, designs, and so on in Wales. And we're lucky enough to have, first of all, attorneys both here and at Harrison and Foot in Leeds. And we've also got present and past examiners. Now, the little bit which I'm going to be talking about, I know whether or not it's appropriate to talk about it now. There are two functions of the Intellectual Property Office, our Intellectual Property Office, and I think most. One is obviously administrative. They will examine your applications for patents, trademarks, and so forth, and they will also hold the ring if folk wish to objectively the registrations, objective grants. But they also perform an important judicial function as well. And that's where I actually have my main dealings with the Intellectual Property Office. And I was thinking that to begin with, I'd just run through some of these judicial functions. So if I could have some slides, Gwenpian. So I've called this IPO and dispute resolution. If we could have the first substantive slide, which I think is next one down.
Yes, they're in PDF.
They are, yes, if that's all right.
Yes. This mouse doesn't.
I can do it from memory.
It's just the mouse. Don't give it enough cheese, Gretchen. No, I don't think I do. It's not simple.
Monday 1 and 10.
Oh, you've got it.
Yeah.
Well, anyway, thank you very much indeed. As I was saying, we know about the registration services. Not so well known are these following services. There are a system of tribunals. We refer to them as hearing officers. Hearing officers are civil servants, officials of the Intellectual Property Office, who sit on behalf of the chief executive, who is known as a controller in patents and unregistered design cases, and the registrar in trademark and registered design cases. I said unregistered design for patents. I'll say I'll explain what I mean about that in a few moments. And they have basically two functions. The first one is to resolve disputes between examiners and applicants for patents and trademarks. But the other thing is that they will resolve disputes between members of the public who have a claim for a patent, trademark, or registered design, or have an objection to the grant of such an intellectual property right. Now, I mentioned tribunals because that's the area we're most likely to come into contact with the dispute resolution provisions of the patent, not with the Intellectual Property Office. But there are two other services. The first is that the examiners will give opinions on the validity and infringement, and on the validity and whether a patent has been infringed. Validity of a patent, that is to say, whether it's new, whether it's involves an inventive step, whether it's capable in industrial application, whether it consists of excluded matter. Those are issues which examiners look out for, and they may say, well, I'm really not going to and third parties may object to registration on one of those grounds. The other thing which they will give opinions on are whether or not the patent has been infringed. And the third set of services are mediation services, which are very cheap, very cost effective, and very good. I've used them a number of times. Now, I've been talking about the sort of disputes which take place in front of a tribunal. They divide into two. There are inter partes disputes, which are disputes between members of the public. And then before that, there are ex parte disputes, which are disputes between examiners and applicants for patents, applicants for trademarks, etc. So if we go to the next slide, essentially, they are the legislation which provides for the dispute resolution as first instance primary legislation, the Patents Act, Trademarks Act, Registered Designs Act. The procedure is usually set down in the rules, patent rules, trademark rules. But there's something which is quite important as well, which are known as tribunal practice notices, which are where the controller, or if he's sitting as he's acting as in trademarks as a registrar, the head of the Intellectual Property Office will provide guidance on how intellectual property disputes should be resolved in for tribunals. And there are two particularly important ones, although they're now overtaken by events. The first one is Tribunal 1/2000, and the second is 2/2000. What used to happen until about 20 years ago is that proceedings in front of registrar or in front of the controller used to go on forever. Attorneys used to produce all sorts of arguments which instead of evidence. There were delays, there were parties were often ambushed, and generally it didn't work at all satisfactorily. Around about 1999, the procedure of the civil courts was streamlined with something called the Civil Procedure Rules, and the equivalent was introduced into IPO proceedings by a tribunal practice note called 1/2000. And although there have been many practice notices since then, that one says basically that we are resolving disputes in a systematic way. Each party is given notice. But if a party plays up, then there are sanctions like costs on costs off a scale. I'll go into that in a second. And generally, it's worked very well. It makes it possible for litigants in person to use these facilities, to use the tribunal. Now, I mentioned 2000. In all litigation, in all contested litigation, interparty litigation, there are costs. But in the courts, the costs are enormous. The costs in the tribunals are literally down to a few £100s, or if it's a contested hearing, both sides have brought lots of evidence, it might be a few thousand, but it's nothing like the costs which the parties have actually expended. And the fine thing about procedure is that there is now a body of case law, and on the IPO website, that's all set, and it's easy to consult. There's also another website called Bailey, British and Irish Legal Information Interchange, which has some of the case law, but generally speaking, the IPO is comprehensive and it's useful, and it usually comes from a case note which explains what the litigation is about. Now, we go to the next slide. I'll go very, very, very quickly over this. The features of proceedings in front of tribunals is that it follows the court, but it's a lot simpler. Often proceedings can be disposed of on paper, which means that neither side has to traipse up to, well, in London, it's now the building where we would have had the UK wing of the Unified Patent Court. It's and in fact, the hearing officers are in Newport, and both sides argue from terminals in that building, or you can go to Newport, or now increasingly you can have proceedings online. As I mentioned costs already, so if you are unfortunate enough to lose a case, you're not talking about something which is going to bankrupt you or wind up your company. You're talking at the most of a few £1,000s. If the hearing officer gets it wrong, the party aggrieved can appeal to the patents court in the case of a patent or registered design case, or to the Chancery Division in the case of a trademark or unregistered design case. And in registered design, oh no, sorry, I got that wrong. Appeal can also like the appointed person of patent or registered design cases. It's to the trade. I do apologise. In trademark cases, you can appeal to an official who's actually a silk or a King's Counsel or an academic or a senior patent attorney, or who sits to hear appeals from the hearing officer. Unlike court, you do not have to get permission to appeal to the court or to the appointed person. The big difference between the appointed person and the court is that the cost limits which apply in the tribunals also apply to appeals to the appointed person. But the drawback is that you can't appeal from the appointed person to anyone else. The advantage of appealing to the court, and the parties who are generally well-heeled will go for that, is that they've got resources to litigate, and costs are on the ordinary court scale, which can be, as I say, quite substantial. And there's always the right of a second appeal to the Court of Appeal, and even in exceptional circumstances to the Supreme Court. We don't want that. If you are a trademark applicant and you haven't succeeded in front of the registrar, then you'll want to go to the appointed person. I'll just go quickly talk about examiners' opinions. This was this was introduced by the Patents Act in 2004. It's non-binding, but it's very cheap. Counsel will normally charge, that's say a barrister or a patent attorney, a senior patent attorney or trademark attorney will probably charge several £1,000s for an opinion. For an examiner's opinion, the cost is only £200. And the examiner, unlike the barrister, solicitor, or a patent attorney, has the advantage that he's going to be able to see evidence on the other side and hear evidence from the other side. It's all done on paper, and it's very useful. It was all. I was actually present at the birth of this because before the 2004 Act, there was a consultation at the Patent Office, the old Patent Office, or the old Patent Office's headquarters in London, and there was one very senior examiner, the hearing officer called Mr. Dennehy, who was running the case for something called re-examination, which is what they have in the United States. The examiner re-examines a patent, see whether it really should have been granted in the first place. And there was another side who were saying, well, what we really need is something which is a lot cheaper than this, something which will give the parties a general idea of where they stand so that they can perhaps resolve their disputes without litigation. And judging it all, well, there were people like me who were making contributions, I think about half a dozen of us, but present in the meeting was Lord Justice Jacob, who was one of the probably one of the best minds on intellectual property we've had for many years. And his opinion was followed by Parliament, and that was that re-examination, as they have in some countries, is basically revocation of hearings again. We've got a procedure for revoking patents anyway. Don't need to have it again. But examiners' opinions could be useful. They're cheap. They're not binding on hearing officers or judges, which is a shame sometimes, because if you win in front of a hearing officer and you win also, and your side's gotten a favourable opinion from an examiner, I'm afraid that the hearing officers and the judges will not give you the costs. They will not consider it any more favourably than they would if you hadn't been to the examiner. But it is useful, and they have been taken up quite a bit. And the decisions are posted on the Intellectual Property Office's website. I, as counsel, when I've been dealing with bright young inventors or bright young artists who've fashion designers who've designed, got a design, often lack the means. I usually encourage them to get before the event insurance. No, they don't always do that, so they have to get after the event insurance, or perhaps find a solicitor to accept the case on a no-win, no-fee, which is very, very, very difficult for IP. But I found that having a favourable opinion from an examiner opens the door to both litigation funding and after the event insurance. So it is something which should be used a lot more. It's used quite widely, and it's something which, perhaps because I was there at the beginning, but it's something I'm very much in favour of. Finally, if we could have a last slide, there's mediation. Now, mediation is, I call it chaired or moderated negotiation. I'm a mediator as well as a barrister and an arbitrator. And I'm actually a mediator for the WIPO, amongst other people. Now, the way negotiations often fail is because the parties do not know exactly what the other side is going to settle for, what their interests are. Obviously, people go into a negotiation and say, well, we want a lot, like Mr. Putin and his idea of negotiations. And the other side will say, well, you're not getting any of it. But both are prepared to negotiate. And the way in which it works, and this it's an oversimplification, but it does convey the essence, is that the mediator is taken into the confidence of both parties. He can't obviously disclose to the other side of the other party, as mentioned, but he can or she can design a set of proposals which would be acceptable to both sides. And it would mean that each would give something away, but nevertheless, there would be something which both could live with. And usually, when that happens, and it happens quite quickly, there's a complete change in the behaviour of the parties. There will be, it's usually an awkward character who will try to trip up the whole thing. Often it's because they've lived with the dispute for many, many years and they really don't know what they're going to do if they didn't have it. But generally speaking, it works pretty well. Now, mediators are probably as expensive, if not more expensive, than King's Counsel. But for specialist intellectual property claims, which are between small and medium-sized enterprises, very much the same as the people we have as tenants, it can be very, very useful. You have all the mediators are examiners, so they are ipso facto, so they are by definition specialists in IP law. And their fees, instead of being, I think, and doubling it, are reasonable. They range from about £75 an hour to £250 for an hour to an 8-hour long session, which would be the sort of thing which you might do in a case which is just outside the range of a small claims track, but it's still important to the parties that they aren't made of money and they want to settle. And that can be done online. It can be done from here. It can be done from anywhere. You can have a party in different countries. Or you can have the mediation actually in Newport. And there again, it's a bargain as well. It ranges from 152.50 an hour to 412.50. I've used it several times, the mediation service. And although I also use other mediation services, and I say I provide them myself through WIPO, it's a bargain. But one service this does not provide, which the IPO does not provide, is arbitration, which is a type of private type of litigation where the parties appoint their own judges. The WIPO has a really good service and cost-effective terms, and that's something which is always worth thinking about. And that, ladies and gentlemen, is about dispute resolution through the IPO, and that's how you can get in touch with me if you want further information. Photo, I think, was taken by the other Nia at our innovation and investment.
Yes. Thank you so much. Thank you, Jane. Should we take questions at the end? We've got discussions and questions at the end. So if you want to ask Jane a question, just write it down or something. Now, so the words I wrote down from your lovely and masterful exposition of the different ways that things can be sorted out through the IPO, the main words I wrote down: cheap and cost effective, and for clients who lack the means. And I think we need to bear in mind that people think of intellectual property sometimes as just being like a wasp's nest or a hornet's nest, that all it is just people causing trouble. But actually, all the intellectual property offices that I know and all that are working really hard to try and make it easier and cheaper, and changing systems to make it to have tracks that are cheaper and quicker, and resolutions to problems that don't involve, decades in court and things like that, which they certainly, can and have done in the past. But there are many ways of sorting things out, as Jane has well laid out, that don't involve that kind of pain. But to go back, to dial back a bit. So what are we sorting out? What is this intellectual property which might need to be sorted out? So I think the rest of the day we'll be talking a lot about the different types of intellectual property. And I'm just going to speak to you for a few minutes, and then I'm going to ask everyone to speak for maybe 15 minutes each on their presentations. But I just want to lay out the groundwork now. So what are we talking to start with? Because it's Intellectual Property Examiners Day, I think we should give a nod to that, particularly because I'm an patents examiner myself, of course, so I'm in that club, So in the room, I'm going to ask, does anybody know who probably the most, apart from me, the most famous patent examiner of all time? Come on. Albert Einstein. Did you know that Albert Einstein was a former patent examiner? Mm-hmm. Yeah, I'm not going to say he loved it. I think he hated it, actually. But he was one. I think, it gave him the freedom to think about, photons and things. So that's good, right? So he was one. And I think patents examining, certainly from my point of view, patents examining for me was something that appealed as being a field that you needed to have a technological background, you needed to have a legal knowledge, and also, because I was a European patent examiner, you need to have some language as well. And it's that kind of interstitial field where you're interfacing with lots of different types of areas, whether it's law, whether it's science, whether it's just doing it in a different language. And for me, I found that very exciting, unlike Albert Einstein was bored out of his head. But I liked it anyway. I think what I wanted to talk about, what always impressed me about the EPO that I worked for, the IPO that you've worked for, the IPO, is the thing about intellectual property, everybody thinks it's going to be incredibly expensive, right? Everyone thinks everything to do with intellectual property is expensive. There is so much information and advice, free, beautifully laid out online for you. The intellectual property offices go to such a lot of trouble to put free training courses online, free patent information online. It's quite incredible how much stuff you can get hold of online. And I haven't got slides. I'm not in the loop really. I don't do it day to day anymore. But I'm sure we can get together for you some information about, if you need to know anything about intellectual property, a pound for penny, it's on there somewhere, And there's a really good illustration of why it's important to look at the intellectual property that's already out there. Today, of course, it's Armistice Day, and we had the 2-minute silence earlier, and people have been thinking very much about war and peace. And during the Second World War, there were a lot of unexploded bombs in London and elsewhere in the country. Just a terribly deadly business for people trying to defuse these unexploded bombs. And there was a particular fuse called, I think, the Type 15 fuse. I don't know any more about it than that, right? That they just couldn't defuse at all. And it was only later on in the war that they discovered, somebody thought to look in the archives or in the patent files in, I think, probably Stapleton Buildings, wherever they were then, in London. And the company, the German company who had designed this bomb, had filed the patents for it in 1935 or whatever. And the diagrams of that fuse were there on file in the patent office. And if only they'd looked earlier, who knows how many lives could have been saved. Now that is, it's a non-trivial example, but a telling example of what lies in the patent files. Now, in that situation, they were literally, buried somewhere in a filing cabinet deep in the bowels of the patent office. But there is no more filing cabinets. There is no more deep in the bowels of the patent office. There is the laptop or the phone in your hand or the laptop in front of you, searching for intellectual property information. It can be done really easily. You can do it via Google Patents using AI and not even have to think too hard. I would advise putting in a bit more work and learning to use things like the European Patent Office's e-bostiwch database or other databases. Other databases are available. WIPO's got a great database. And if you just get a bit of familiarity with these, and your own topic, you can find what your competitors are doing, what's already been patented or whatever in the field. And also trademarks, a similar thing, also designs, you can have a look and see what there is. And this can save you a lot of time. And I think really you're going to be hearing a lot about, and this can save you a lot of time, and this can save you a lot of money. I hope that everyone's going to say that at some point today. But I would recommend, if you are active in a field, to just get a bit of familiarity with these busnet and those type of tools. And there are free online ways of learning how to use them and things like that. And other thing, the whiteboard database has always really impressed me, because one thing you can do on that is you can find a particular patent that, say, it relates to a technology you know about. The inventor's name is there on the database. You used to be able to click and link and get their LinkedIn. You used to be able to, so you can tell who in a company is likely to be interested in your technology. So not using it as intellectual property, but just using it as a sort of secret passage into a company to talk to the very engineer or the very person or the very designer who is most likely to be able to collaborate with you or buy your thing or tell you how to coat your device, you need coating, whatever. So intellectual property information, which is gathered and put out there by intellectual property offices for the benefit of the public, for the benefit of the world, really. It is, the world is your oyster in those terms. So really, I can't stress enough how much, if that's the type of field you're working in, I would really try exploring it, because it's astonishing what you can get hold of without putting any money out there at all. So I wanted to say that about patents and information. Having been an examiner, that was my job. It wasn't on computer then. I was telling Robin earlier that I was a patents examiner, and he said, "Oh, were there computers then?" He said to me, "I was given it for that." So to be honest, maybe later. But yes, there were computers actually. I mean, Babbage had been going for quite some time. But it is true. We didn't use computers to search patents. We used great drawers of patents and carrying a big muscle carrying huge stacks of paper onto your desk. And so that's how it used to be. None of that anymore. It's just click, click, click. Keyword searches, classification searches, get scripts with classification, brilliant things. So that, I think that's the end of what I wanted to tell you, was that this information is there. It's just sitting there waiting for you to use it. There are training courses there, just sitting there waiting for you to engage with them. Please, if that's of interest to you and people online, I'm sorry, I'm not talking to you at all, but please, really, really explore it. If you need to know more, ask us and we'll send you some links later. But there's an awful lot of information there. So that's all I was going to say. I'll probably be mean to you again before the end, if that's all right. So I think you deserve it. No, I'm not going to. Oh, I'll tell you what else I should have said, and I'm very sorry I didn't. Jane, I asked you to introduce yourself, and you haven't bigged yourself up enough, and I'm going to read that here about Jane. So we do know that you are an IP barrister at law, which I should have said before you started speaking. And we know that Jane supports patents and trademarks, but she's very, very active supporting people here at M-SParc. So thank you so much for coming and for giving your expertise. I should have bigged you up sooner. I've done it now, so you can forgive me for that. So the next person I want to ask to talk for 15 minutes is on screen, Joe Foote, whom I don't know, who is, it says here you're a dedicated trademark professional. I suppose just a nonchalant one, I suppose, based in Leeds, and helping businesses to protect their intellectual property and brand identities, which are really important things, at least that, if not more important. So Joe, can I hand over to you?
Excellent. Can everyone hear me and see me?
Yeah. Yeah. Not mute.
It's the computer's on mute, yeah.
Because
you can see the
yeah, so there we go.
Okay, awesome. I'll just put my camera on now for the first bit and then turn myself off. Gwen, just let me know if everything's working when I do click present. Does it? So,
Is that right? Yeah, so it's
not giving you quite the right thing, is it?
That's right.
Yeah.
That works.
Are you seeing all my notes and everything, or are you just seeing the slides?
No, just slides. Just slides.
Just the slides. Fantastic. Yeah. All right, great. That's brilliant. I'll just flick my camera off so everyone can focus on the thing. Fantastic. Okay. Yeah. Thanks very much for the introduction. First of all, thanks so much to Jane for asking me to do this. It's always an awesome opportunity to get to speak. As you can tell, I probably won't have as many stories as some of the other speakers about the history of IPOs and things like that. I'm a little bit younger, but it's just really cool to be able to do something like this. And thanks all for having me. As you can tell, I have a very, very, very southern accent. I've been in the UK for about 2.5 years now. In Leeds, as you said, I'm part of a sort of very small boutique practice. We've just formed it under a year ago called Harry Foot's IP with a good friend of Jane's, Michael Harrison, who couldn't be here today, so I'm here in his stead. Yeah, I'll get straight into it. The first distinction I want to make is between trademarks and registered trademarks. So a trademark in the everyday sense is simply your brand, your name, your logo, something on your packaging. It could just even be a product name or of a slogan. But the moment you start using it in business, it functions as a trademark. However, if that trademark isn't registered, your legal protection can be quite limited, as you do not get access to key segments of the Trademarks Act in order to enforce it. These sections being 5 for oppositions and 10 for infringement. When you register your brand with the UK IPO, you get a strong and clear legal right, and there's elements to enforcing an unregistered trademark, like proving goodwill or that there's been actual confusion with another mark. And you don't actually have to do those if you have a registration. You rather just have to prove that a similar mark is a confusingly similar mark is being used for similar goods or services, and sometimes that there is a likely confusion rather than actual confusion. This is faster, cheaper, and more straightforward. And also, lastly, as you can see, I've put the little superscripts, which look probably quite familiar to most of you. If you are registered, you can use one with an R, which is sort of a badge saying my trademark, my brand is protected by law. So there are several types of registered trademarks. The two first are the key ones I want to talk about, that being a standard character word mark and figurative marks. I'm sure those examples I've chosen are quite familiar to most of you. They are certainly capable of guaranteeing the quality of the services by the proprietors of them. A word mark, that's the first one. You can see all blacks and italics. That protects the name itself, this being the letters, the wording, the way the name is pronounced, regardless of how it looks. And this is, generally speaking, the broadest protection because it stops people using a name that sound and look similar, even if, you know, the way that they present them is different, like the design or the font or the way it's spoken. A figurative mark, that's the next two. You can see the first one contains words, the second one doesn't. Both are registerable, but it protects the visual appearance of the branding. This is ideal if you have something very distinctive like a fern in your logo that consumers would recognize. Theoretically, for these, overall protection is slightly narrower, as there's less protection offered for the oral and conceptual nature of the mark and the brand. However, I do routinely read decisions where hearing offers consider these elements when comparing figurative marks to other marks. So there is still some protection, but it's not as strong as for the word mark. The two other ones down below are sort of, the first one being a series mark, which is actually pretty much unique to the UK IPO. It allows you to register very similar marks in one application, sort of a small group of them. But I've recently been told by the UK IPO that these are on the way out because they don't sort of translate overseas. If you are going to expand protection, you can only take one of them. And in all honesty, they're often really not used for their original purpose. Typically, a trademark attorney like myself will file 2 marks that we know are not really part of a series, but to get to both examined in one application, which has been handy. But yeah, I think they're on the way out, and rightfully so. And then the last is collective and certification marks. These are different, but I'll discuss them together. A certification mark, rather than distinguishing one business to another, is used to show goods or services meet a certain standard. And then a collective mark is used to show that members are part of an association. Now, how this could be relevant to what you do. For example, someone invents new technology that is more environmental friendly than the previous iteration that was commonly used. You could apply for a certification mark and get that registered and license that out so that anyone that, sorry, not license it, but say that anyone using your technology can have your certification mark, which will display to the consumer that the technology they're using is more environmentally friendly, which would obviously be commercially advantageous. Moving on, why businesses need registered trademarks. Obviously, a badge of origin should serve as a guarantee that the nature and the quality of the goods or services for which the mark is used. And only you should be able to take advantage of your own reputation. So, you know, as businesses grow, I think it was mentioned at the start that a lot of you are sort of already succeeding businesses and thriving. You want to make sure that only you can take advantage of that. Secondly, a main point is the facilitation of investment and licensing. I'll probably touch more on the licensing later, but a registered trademark is often extremely helpful when seeking investment because it shows that your brand, one of your most valuable assets, is properly protected. Some of the sort of most rushed applications I get instructed for are clients who have secured investment, particularly American investment, and the investment is conditional upon them having a registered trademark or at least an application in. So they're obviously very useful in that regard. This is just sort of a home slide for the next step that I'm talking about. I'm just going to talk about how I can help you get a registration. I like to think of it divided into 3 key stages, that being pre-filing. That's when I talk to you at the start. We take instructions. We decide how we are going to apply and whether the initial sort of application the client proposes is a good idea. Secondly is post-filing and pre-registration, how we sort of deal with the UK IPO and any previous right holders to try and get through, and then post-registration, which is once you've got the asset, how can we best use it? So the first key stage in obtaining trademark registration is pre-filing, and if everything does go totally as planned, totally optimally, that meaning the trademark gets through unscathed by the examiner or an earlier rights holder, then most of the hard work will have been done at this initial step. And now I'm just going to go through exactly how that would look with a client. The first thing we would do, have a chat following your initial engagement. This could just be over the phone or an email. And after initial assessment of whether the mark is worth pursuing, we'd look to do a clearance search. Now, this is a very key, in my opinion, a very key aspect of obtaining any sort of IP right, but particularly trademarks, because we very much do it ourselves. It's quite really collaborative. We want to find out 2 things. The first being if there's evidence on the register to suggest that a borderline trademark is distinctive enough to pass through examination. Now, I'll go over this a little bit more in a bit, but oftentimes clients will come to me with a mark that's sort of a bit touch and go as to whether it can serve as a badge of origin. It could be slightly descriptive or slightly generic, but we'll always look at the register to see if there's other marks that would suggest that something similar could get through. And then the second thing we're looking for is if there's an earlier registration that could be used as a basis for a successful opposition. We'll report back to you on the findings of this and decide on whether we should go ahead. This is, again, a very collaborative conversation. We might suggest adding another element to your original mark to make it more distinctive or take it further away from a previous registration. Or we could say, right, well, let's start again, go away, brainstorm again. This is often if it's at the early stage of the client's business, and say, come up with something totally new, and then we'll search again. So after that, if all results are positive, we'll draft a goods and services specification. Every trademark has these. On the register, it will essentially consist of the mark itself and then what it is protected for. Trademark classes are categories used to organize the goods and services specification. So there are 45 of them. We use the NICE classification, which separates, yes, as I said, 45 classes. 34 of these cover goods and 11 of them cover services. I say to clients not to worry about these too much. It's mostly the purpose of them is administrative, because it sort of, divides an application up, and it's useful because the UK IPO charge per class. Most property officers do, and so do attorneys. It's just a good indication of how big an application and how much work it's going to be. If it's 10 classes, it's going to take longer than 2, and it will cost more. But my job is essentially to translate what the clients tell me their business does into some of these 45 classes for filing. If the space the trademark will occupy is quite open, meaning there's not too many earlier registrations, we'll often file quite broad terms, although this is recently there's been a little bit of a change to this, as there's been quite a landmark bad faith decision, which I won't bore you too much with. But essentially speaking, we want to try and get you the broadest protection we reasonably can within what you're going to use the mark for. So if there's lots of marks on the register that are quite similar, but maybe we've decided it's worth the risk, we could file very narrow, extremely specific on exactly what your business does. Or alternatively, we could file quite widely with slightly broader claims, still what you genuinely intend to use the mark for, but offering us broader protection against future infringers. After filing, you've got your registration, everything's gone well. The first thing we have to get through is the examiner, which I'm sure you'll learn much more about, I think, mostly from the patent side. But when you're, as you can see, it takes about 2 weeks from the filing date. It's often much faster. It amazes me how quickly they get these back sometimes. But the first thing that is assessed by the examiner is whether the trademark possesses sufficient distinctiveness to act as a badge of origin. This is absolute. This is what's called an absolute ground. And the examiner essentially looks at, like, whether your trademark is the kind of sign that can help customers recognize that these goods or services come from a particular source. So what it can't be is descriptive or generic. A really classic, boring example of this that I use, that if the word apple would be seen as descriptive if Steve Jobs ran an orchard, but it was fine since he was making computers, if that makes sense. So secondly, the examiner will assess whether the description of the goods and services are clear, and all of the wordings are in the correct class. This is usually pretty easily overcomable. You might just have to be a bit more specific about one of your claims, or move a class and pay an extra 50 quid or something like that. It's usually pretty easy to overcome, but often involves more collaboration between the client and attorney just to decide whether we're maintaining the core of what you really do. Then the third bullet point on this first stage of post-filing, the examination, I've put a question in that I discussed at length with Michael, who's Jane and I's mutual friend, of whether this is an exact science or dark art, because very often we advise clients that we're quite unsure of what the result of the examination is going to be prior to filing. There's a lot of subjective factors that go into it about descriptiveness and genericness and whether it's generic or not. And in the end, we quite often say to clients, look, we're not sure. This may be very well worth pursuing. And there are mechanisms by which we could overcome a negative decision, but more often than not, these are unsuccessful. And this is what it costs. This is what we think the chances of success are. And if we do not succeed, this is the plan of attack that we go for afterwards. But if an application does move through examination, the mark moves into its opposition period. This usually lasts 2 months. An earlier rights holder can extend this by filing a notice of threatened opposition. If faced with this, a threat or an opposition itself, what we would do for the client is contact the earlier rights holder and sort of we usually do this quite cordially at Harryfoot and just see, look, what's going on here? There's obviously a bit of an overlap. How can we both alter our position to, it's advantageous for both parties? Is there a way that we can alter our position slightly to make sure that we can both coexist and trade without sort of commercially disadvantaging each other? Failing that, we would assess whether, if an opposition was to come in, it would be worth defending, and then ultimately make a final decision with the client on how to proceed. Moving on, hopefully none of that happens and we just get straight through. You've got your registration. As previously mentioned, it's a very valuable asset and should be utilised. The first key thing to note is use requirements. In the UK, a trademark becomes vulnerable to cancellation if it is not used for a continuous 5-year period. This is obviously something to keep in mind when beginning the application process. Is you should be confident that you'll use the mark that you're applying for within 5 years. And some other jurisdictions have a shorter 3-year use requirement. Enforcement was touched upon in the first slide. The UK IPO will notify you where there's an application containing a mark they consider similar to your registration. However, you can also set up sort of watch services with tailored software that sort of will capture a wider range of applications and also sort of online potential infringement. Obviously, look, you've got the asset, you want to make sure it's used appropriately, and at any point, you just sort of re-instruct the person that helps you get the mark. It's often more likely that the rights owner finds the infringement than we do, and we totally encourage you to sort of keep an eye out once you've got your registration, because as you say, you're more active in your own market than we are. Licensing was touched on in an earlier slide, but not in too much detail. It's another way in which a trademark registration can be utilized, obviously a really effective way to expand into new markets and increase revenue and support partnerships without having to give up or sell your rights. We can assist you in negotiating licensing arrangements, drafting the agreements, and filing these with relevant IPO officers, which is always a good idea. It's actually a really good service that the IPOs do, I think. Makes total sense that they would sort of take on and file things like licensing agreements, trademark assignments. They're all kept on, and it can just serve as a really quick stopper to any sort of potential ongoing issues that can arise from them. As was previously mentioned, it's World Intellectual Property Organisation Day, and once you've got your UK registration, it's something your business is interested in, and we can always help you with expanding that internationally. First thing I want to discuss in this regard is convention priority. Within 6 months of the UK filing date, you may file the same application in any jurisdiction that is party to the Paris Convention. And that's 181 countries. And then you can obtain protection from that jurisdiction from the original UK filing date. What this does is it protects trademark owners from bad faith registrations. That meaning if someone spotted your UK trademark in a different jurisdiction, understood that your business was looking to expand into another jurisdiction, without convention priority, they could theoretically spot it before you file, and then they would have an earlier register right than you, which could be quite hard to overcome in that next jurisdiction. But convention priority sort of provides a really nice safeguard to this, that within 6 months that you could obtain protection of that original UK filing date, and you would have the earlier right. Often the most simple way to do this is directly through the World Intellectual Property Organization and the Madrid Protocol. As previously mentioned, these IPOs and WIPO are doing things all the time to cut costs. This is just a central international application made directly to WIPO, where you designate chosen countries. So it goes to WIPO and then to the designated countries following that, without sort of having to instruct a foreign associate and the intermediary. You often do afterwards, but this is far more cost effective than individual applications. Just lastly, a couple of things that I would just advise you if you are looking to register a trademark. There's much stronger right to registered marks than unregistered rights in the UK. And if you're considering using a mark, or particularly if you're already using it, at least inquire about the registration. And then secondly, just if you're dealing with a professional advisor, even though some areas of trademark law are more of a dark art than an exact science, ask as many questions as you need in order to totally understand your advice. This could be sort of asking for literally a percentage chance of success, or exactly what the cost of the appeal could be, considering, if the current examiner's objections could not be overcome at this stage. When faced with a challenge to a trademark registration, there's almost always something that can be done. But the longer I do this, the more I realize the advice that often really matters is weighing up whether to try and overcome the current challenge or to sort of cut your losses and go in a different direction. And that's it for me today. Once again, thanks so much for having me. My details are on the screen, and I'll send these slides to Gwen in case any of you would like to contact me after this and further discuss anything.
Thank you so much. Thank you so much, Joe. And will you be around if there are questions in the question session later?
Absolutely, yes. We can do these do these now or later? Yeah, however you prefer.
Well, it's on the agenda. I'll do it all later.
Yeah.
Thank you so much.
Excellent.
And the things
Thank you.
it struck me, to go back to my thing about things being good value for money, as you pointed out, there is a cost involved in filing a trademark, but as you said, it's faster, cheaper and more straightforward to defend a registered trademark than to try and stand on one that isn't registered. So that, you know, it's a bit of a hit up front, but it's kind of well worth it, particularly if it's a valuable asset in your business. And I like what you said as well about working out whether to cut your losses in the early stages. I've often spoken to people who are very fond of a particular trademark, but in fact, it's, I don't know, it's EasyJet or something. You think, no, don't do that. Don't use that one. That's not a good one. And if people are, you know, whether they if people are intent on using a mark, but you know will get into trouble, it's much better to cut your losses at the beginning, before you've built your business, before you've built your brand. Change the mark, as Joe was saying, you know, then that's the time to do it. So you describe this as a dark art, and I would say, to coin a phrase, that all these people are here to help you to defend against the dark arts. That's a good phrase. I think I'll use that in a book. Anyway. So thank you very much for that. Thank you, Joe. So the next person we have talking to us is Sean. Sean is a director at Thomas Harrison Intellectual Property Experience, certainly it says here, who has worked at a number of organisations giving IP and patent advice during his career. So I will pass over then, if that's all right.
Yep.
PowerPoint. Just use buttons then.
On
Here we go.
the presentation.
Yeah, I can do that. Doesn't really show here. It is in.
Yes, is it?
Yeah.
Because you're sharing it.
Yeah.
Right?
I see.
I'm afraid you're sharing all your secrets
I'm
as well.
sharing. Got any secrets? I've got any notes. Thank you, Mia. And thank you, Glenn, for organising this, and Jane too. Yeah, my name's Sean Thomas, Thomas Harrison IP. Yeah, I joined the IP profession about 25 years ago, working for some large patent attorney firms, and there I worked for some large corporations, and also entrepreneurs and inventors. And I sort of learned that inventors and maybe startups had very different needs in intellectual property to the large corporations. But in addition to working in the patent profession, I've also invented products myself, gone through the founding, startup, commercialized them, raised money, and got the products. It was a medtech product, got it into the NHS. So I think what I've learned from my experience is that what's needed in patents is a strategy in all intellectual property. So it's not just about getting certificates, putting them on the wall. That's a very expensive way to spend your money and your budgets. And also, it doesn't get your company into the best commercial position. So I thought I'd just sort of go through patenting basically, and from the perspective of using, relying on my experience both as a inventor and founder of startup, and also from sort of working in the IP profession as well. So talk about, so firstly, what can be patented? I'll briefly run through this. So ideas and inventions which are industrially applicable must be of a technical nature, So it must be a product, system, method, or a process. Software can be patented, but it must be of a technical nature. Different patent offices throughout the world have their own procedures for determining what is of a technical nature. So the thing to take away from there is that it must be of a technical nature to be industrially applicable. So that's the first test for patentability. The second is novelty. So it must be new. So you can't get a patent for anything which has already been done before. It is out in the public domain. The novelty test is worldwide. So it doesn't matter whether if it's been out in the public domain in India or China or anywhere, and you file a patent today, if it's already prior art out in the public domain before today, then it's citable against your patent, against novelty. And any prior art has to be an enabling public disclosure, so it has to enable the public or somebody who's skilled in that field to be able to carry out the invention which you're trying to patent. So that's two of the tests. And then the third one is inventive step. So it can't just be an obvious development of what's already known. So if you get two machines, put them together, that two machines which are known, put them together and get a known result, then that's just an obvious thing to do. So that's not patentable. If you get two known machines, put them together and you get an unexpected result, then that's potentially patentable because it's not obvious. So those are basically the three tests which you need to get over to pass before a patent is granted. So you get a granted patent. So what's the deal? Well, you get 20 years monopoly from the filing date. So you can. So anybody who wants to use your invention, they have to get your permission to do that and get a license from you, or you can simply not grant one if that's the best thing to do commercially. So one thing to note is you cannot enforce a patent until it is granted. So if you know of an infringer, you may want to accelerate the procedure with the patent office and in order to get the patent granted quicker so you can then enforce your rights against that infringer. Nothing to bear in mind is renewals. They're due every year for every patent in every country. So really you've got to think where your main markets are. It's not feasible to get a granted patent in every country in the world. So you can't get, it's just not financially feasible. So you have to have a strategy, just knowing where your market is and how best to protect your product. So the other part of the deal is, so you get 20 years monopoly. So what do you give in return? So you give society what you've invented, your new technology. And in order to do that, your invention must be sufficiently described in the patent document for other people, for the public to be able to work it when it's published. And then the patent application is published at 18 months. So nobody knows what's in the patent application until it's published. So you file it on month 0, and then it's up for 18 months until anybody else can see it then. And I think the publication is often overlooked, but it's quite an important date, because if you file a patent and it's quite clear early on, maybe from the patent examiner's search report, something that you're not going to get a granted patent, you may want to withdraw the application and therefore prevent publication, so that then you still keep the contents of it secret. So the publication date is quite important, but often overlooked. So why patent? Well, there's lots of sort of strategic advantages. And the thing is, in having an IP strategy, really your IP strategy has to align with your commercial objectives. Like I said, just getting certificates for patents is just an expensive way to burn your money, basically. So you have to understand what your patents are going to do for you. And then you have to file the relevant patents, and this includes all IP really, which can give you, for example, competitive advantages and market exclusivity. Obviously, it gives you legal protection to enforce your rights. And when you file the application, although you have no rights at that time, you have a filing date and you have an application number. So you have patent pending status. So you can launch your product as patent pending, and nobody can actually see what's in your patent application. So it acts as a deterrent against the potential for anybody, third party, sort of copying you. I mean, it doesn't give any rights to stop them, but they have to think twice before they actually copy it, or infringe, or potentially infringe your patent. So it can attract investment because obviously there are assets, it's an intangible asset, and it de-risks investments. So it can attract investors to invest in your company. It's also potential for a strategic negotiating tool. So if you are in a conflict and need to negotiate with maybe a competitor, there's the potential to cross-license technology. And so leave your company into a sort of a better position from a negotiating point of view. Obviously, you can license the technology because you have the rights. So you can license all or part of the technology, and then you can license all or part of the technology in different geographical regions. Then, of course, you can, because you have exclusivity, there's the potential for your product to sell at premium pricing. Find that if you have patented something which is really advantageous, then there's maybe some technical advantage, or it may be able to do something quicker. So it might have an advantage over the competitive products. Tax advantages, patent box. So that allows you to have quite a big reduction on your corporation tax for all revenue, which is generated from sale of the product anywhere in the world. So that's just if you have a UK patent, it's relevant for all sales around the world. And it obviously increases revenues, profitability for your company, increases enterprise value, so which is a great advantage if you're planning to exit, sell the company on. And of course, it provides some reputation and credibility in the marketplace. As we know, there's lots of car manufacturers who boast about how many patents they have covered their technology in their cars. So those are just some of the reasons why you might want a patent from a strategic point of view. So then the process, I won't go through all this because I haven't got time, but basically this is the application procedure for the UK. So you would file a patent at the top there, an application at month 0. Now you don't have to pay the application fee or request the search for 12 months, which is, dot 3 down there. But I think a good strategy is often to request a search on filing the application, because then within maybe 3 months, 4 months, you obtain the search report back from the examiner, and you can then assess it to determine whether you're likely to get a granted patent or not. That gives you an idea then of how to plan a strategy going forward. Because if you're seeking patent protection in other countries, that has to be filed an international application or a foreign national application. That's to be filed within 12 months of filing your British application. And that comes at quite a significant cost. So if you're not requesting the search, for 12 months, you're really incurring the cost of filing an international application blindly without knowing the likelihood of getting a granted patent. So the strategy of requesting a search very early on allows you to sort of plan ahead. One, if you're going for an international application, whether it's worth doing that. Secondly, if the examiner comes back and completely knocks your invention out of the water and says there's no way you're going to get a granted patent, there's always a potential to amend the claim slightly, change the scope of what you're seeking a patent for, and then proceed on that basis, or refile the application if the scope has to be changed considerably. You probably need to refile the application, but at least at a very early stage. And again, the application is published at 18 months there, and then it goes through the procedure until it's either granted or refused. So international, then I mentioned about you have to file an international application within 12 months of filing your UK application, and that's under international law. And that allows you to claim the filing date of your British application for your subsequent international application. Again, so this shows the...
Just to make that mistake, I am getting iller as the day goes on. And I've taken some time.
Yeah, thank you.
So the British application filed at month 0 there. So you can file an international application or file in any other foreign countries which are party to the Paris Convention within 12 months. And then really from that 12-month stage, again, you can see the international application is published at 18 months. But from that 12-month stage, you really need to start thinking about where you're going to need to get patent protection, because it's not financially viable to actually get a granted patent in every country of the world. So you need to work out a strategy of where your main markets are, where maybe your countries, some products, usually in Europe, you'd cover UK, France, and Germany, but then some clients may want to cover the Netherlands just to cover the big import routes there. So you'd want to cover manufacturing, technology capability, but you really need to know by that month 30, because that's the date when you have to decide in which countries you want to seek patent protection. So you can see the month 30 is 2.5 years later after filing the UK application. So you have 2.5 years basically to not just to sit on your patent application, but to actually work out a strategy, because month 29 is not the time to start thinking about where you might want to have protection for your product. So this is just as part of the strategy. This is just a few things that you need to consider. You need to align the IP strategy with your business plan and your commercial objectives. But like I said, it's not just a certificate. It really needs to be active within your business and to enable your business to meet its commercial objectives. You have to know your key markets for your product and the territories, and understand which countries have the technical capability and the manufacturing capability, and also which are your biggest markets, obviously. Obviously, there's cost versus certainty. If you accelerate the procedure, then you're going to have the costs more upfront, but that gives you more certainty of whether you're likely to get a granted patent or not. So you've got to weigh those two up against each other. And again, accelerate or slow down. You can accelerate the application. You can get a granted patents in the UK sort of within 12 months, certainly, maybe some companies might want that if they are very interested in the patent box and want to start having reductions in the corporation tax. Or if you know of an infringer, you might want to accelerate the procedure to get a granted patent. Alternatively, you might want to slow it down if you're on a restricted budget and you want to spread the cost over a few years. And then obviously the broad scope versus narrow scope. So, you know, as a startup company or an entrepreneur, and you've just got an idea of an inventive concept, you probably want to draft the patent having a very broad scope, just cover the whole concept. And so basically have the core invention in there, but throw everything in there, including different embodiments. Because you can always, once they're in there, you can always file a divisional application off that, off your main application. You can't add anything in to broaden the scope of the patent application after it's been filed. So quite often a broad scope of the patent of the invention is better for a startup company starting at. A narrow scope potentially is for improvements, maybe for bigger corporations might be making iterative sort of technological advances. So they may do file patents having a much narrower scope. So that's it. Thank you very much.
Oh, yeah, thank you, Sean. So we've talked about this dark arts, and you set out a sort of Faustian pact that patents are. It's a deal whereby you tell people everything, but you get a monopoly. And you also talked, I think I like the fact that you talked a lot about strategy. It's really important to have an IP strategy. And I think hopefully that everything everybody says today will build towards you realizing that you do need a strategy. It's not just a question of shooting off money at everything without thinking, oh, like we all have enough money to do that anyway. But if you have a proper strategy, you know where your important things are to you, where your important competitors are, your important markets are, you can make much better decisions. And particularly you mentioned the patent box, which is something I think that really is a dark art that people don't know much about. And as so are R&D tax credits, actually, which are not really to do with patents, but they are something that you all, if you're doing research, you should know about that because it's essentially free money. So free money is always good, right? So so thanks for that. That brought up. So there's just one speaker left that I'm just siarad yn Gymraeg. Yeah. Hanner. So you may need to, so half it's going to be. So you may, if you need your translation devices or to do whatever magic you need to do online to make the translation work. So I have actually.
Yes, thank you. As we've all spoken, as you know, we've got to have a bond.
Yeah, we've got a bond. Exactly. I have forgiven.
That's your day.
That's why we're here.
We're going to hear from Robin. I'm going to speak in Welsh, okay, so put your thing on. So, sylfaenydd a chyfarwyddwr eiddo chi.
Eiddo.
Eiddo?
Yes, I think you need the wrong ar LinkedIn.
Eiddo, you're...
Yeah.
A mae hynna'n bwysig iawn I ni wybod na dyna da ni'n sôn amdan, eiddo, da ni'n sôn amdan. It's your thing, your ideas, your property. I like that.
Thank you.
Cyn i hapus, Robin. Cynghorwyr eiddo deallusol yn cynnig gwasanaethau trwy'r gyfrwng Gymraeg. Yn darparu ac yn cyflwyno ceisiadau o ran busnesau bach a sefydliadau cymunedol, mae'n bwysig hefyd. A er mwyn gwarchod y syniadau a hunaniaeth diwylliannol. Geiriau mawr. Oce, drosodd I chi, felly.
Dwi'n siŵr ar LinkedIn neu fath yna. Ie. Wel, ydych chi'n plesio. Ie. So, jyst hwn i'r pethau. Dwi'n brif, so dwi'n arholwyr patentau. Dwi'n bod o'n i yna 10 mlynedd. 2015 I 2025. Dwi wedi gadael fan, a wedyn dwi ar fan bod newydd. So, pam ydyn ni yma? Why are we here? I ddathlu pobl tu ôl i'r patents, really. A dim ochr yr attorneys neu'r agents, ond ni. So, mae yna dros 20 miliwn o patents, dwi'n meddwl. Da ni'n gorau chwilio drwy. A wedyn, Mae'n bwysig i ddall bod ni chwilio drwy lot ohonyn nhw. So, mae eisiau dathlu ni. Anyway. So, dwi eisiau trio esbonio chi y rôl arholwr, basically, mewn ffordd hawdd i ddeall. Ond mae pawb yn un eitha deall at fydd yn pattern study, so mae'n iawn. So, yr un nesaf sbwch yna. Ie, nas ni aras, dweud, roed 2 lun yn efo. Oce. So, sut mae arholwr patent yn troi syniadau i innovation sy'n cael ei diogedi. Be da ni'n trio gwneud? Swydd ni oedd yr office oedd trio cael the best patent possible. Dim so, sa'n ni wedi gallu chwilio am oesoedd ac oesoedd, a di gwario gormod amser, ond mae hynny'n wastraff. So, be da ni'n gwneud? Trio ffeindio y patentau sydd yn mwy debyg, a mae hyn yn rhoi, so, our job is to do the best job searching for similar patents and to find the nearest ones. And that gives then the applicant an idea of what's infringing, what's near, or is that a brand new idea? We'll go next slide then. So what does a patent examiner do? So we receive an application from an agent or sometimes by someone underrepresented. So it does happen, and I've dealt with that several times. Fydwch chi clicio ar GB I weld os yn eitha weithio. It should open a So essentially, this has to scroll out pretty much. So this is one of the patents I've done, and we get a series of claims, an abstract, which you can see there, and a description. So with those 3, we try and figure out what the invention is and the best way to search for it. And after that, we file an internal search report for internal, and then we send an external form out. And if you go to the last page of that, you'll have to use the
School.
that's it.
This.
Oh, you can actually go over the top where it says,
We have the claims.
yeah, we can go to the claim. Oh, well, we'll go to claims, yeah.
Click on a menu.
Yay. So that's what we get. So the examiner had to look through all of that to make sure that, it's clear. Well, that's for an examination, but for the search purposes, we're going to find out if it's one invention or 2 inventions. And we only allow 1 invention to make it fair for everyone. So if we determine there's no plurality, we can continue our search. The second thing in the search is to make sure it's not excluded matter. If it's like a computer program, or it's very touchy, but we use section 75, I think, which is, this is excluded matter, we're not going to search it. So that we send that out, and then the attorney sends it back and says, we think you're wrong. But there you go. So then, and if you go to the last page, which is search report, I think, on it, this is what we produce. You have to go in the.
Oh, sorry.
Yeah. That's this fast step, by the way. It's very good.
Yeah, that's brilliant.
Mm.
It's good.
There you go. So I didn't do that search, but there you go. So this is what the agent or the applicant will get. And we like to think of ourselves as a quick, cheap and efficient way of finding out if your application will be novel or inventive, because I think it's £200, you file for a search report, you'll get it within 6 months, or if you want it accelerated, it's green, you can have it done in 3 months. so that's pretty good. And while the European patent EPO, they take a lot longer and it costs a lot more, if I'm not mistaken. So there you go. Okay, and back to the slides, please.
With me now, I'll get the slides back up.
No, back in. There you go. So after we search, they have now called something called the Common Search CST. Tool. There you go. So in Europe and the UK, they have the Common Search tool, which searches all of the patents you've got. It searches for the abstract and the description and everything. So it's very, very good. I don't think if you click on reports, I don't think it'll show what I've got because we'll see anyway. Okay, fine. It was just one of my reports. It was a very lengthy report where I decided if it was a unity invention, if it was novel, if it had invented step, and also if it conflicted with a EP patent. So you can file in the UK, and then you can file in the EPO that designates GB. So then you have two British patents, and you can only have one patent for one invention. Can't have two. So that's what the examiner does. So next slide, please. So what am I doing here? Oh, this is an example. So a startup at M-SParc designed a new wind turbine control system. So the examiner searches patents from Denmark, China, and the US, and we determine what's the novel bit of it and if it's novel or not. Next slide. And then it's just about, we get every kind of technology from small things to big things. So we from a Catholic smartphones, most things here have had a patent on them, either expired or not, and we get different things like cars, all the way to tractors, everything you can imagine. And we have a very varied background. I've got a background in electronic engineering from Bangor University. But we've got teachers, mathematicians, chemists, and everything. So it's really, well, the biology one is very important because of medical patents, and they take a lot of understanding. So yeah, so good quality background. Please. Oh yeah, but this is just the skills required to be a patent examiner. Well, normally a degree in science and engineering, it's a good start, or you can have training if possible. However, as a patent examiner, I got a diploma in intellectual property law through work, so that's quite good. You've got to be analytical, curious, fair-minded. And with that, you can have, work with the IPO, you can have international multilingual connections because we work with the WIPO, with the classifications, and we send someone to Switzerland. So yeah, so next slide, please. Oh, a day in the life of a patent examiner. Where am I? Yes, we read patents, scientific papers. We keep up to date with the development of the intellectual property law, see whether it affects the Act. The Act is what we use to determine if it's a good patent or not. And then you write reports, you send feedback to patent agents or attorneys. Sometimes you discuss them on the phone, and we occasionally deal directly with unrepresented applicants who phone you in the middle of the day saying, what's happening to my patent? Can you help me? So can be yeah. We also collaborate with other patent offices, and I personally was a technical training manager. So I collaborated with other businesses and attorneys to have in-house discussions about what's the latest technology in their field. So yeah, that was quite interesting. What else is there? Why does it matter to Wales? Quality examination is strong rights for Welsh inventors. It helps small businesses attract funding and grow and builds a fair system that encourages innovation. There you go. I think that's it, isn't it?
Oh, thank you. Diolch yn fawr iawn.
Oh, there you go.
Cwestiwn in Saesneg.
Yes.
Yeah, okay. Do you have any tips for some of the people who are making applications for patents? What will actually irritator patent examiner.
Oh,
And what will, I mean, I'm sure Sean will also want to say, well,
Any tips to irritate you?
what do we avoid anyway? But that's the main thing. What do we avoid? Say that you don't raise an objection.
Well,
They come to me.
yes, well, we've recently introduced a new, well, not we, the office introduced, but last year, you had to pay for every claim after 30. And I've had several applications with over 100 claims in them. They are not fun. And we have the same amount of time to do, you know, so you have one with 3 claims or one with 500 claims. You're set the same amount of time. So it's really annoying. So don't put 500 claims.
We're actually talking about things which irritate examiners, so we can avoid it for our tenants. And,
I think the UK examiners are probably the most helpful
Yes.
around the world. Definitely.
Yeah.
And you know, it's like they work with you to try and get
the best
granted patent. So
I think that's a really good, if people learn only that from today, it's that there are people there, the people, particularly as you said, the UK IPO, and you know, I would say the EPO, of course, but there is really just want to help you do to get to where you want to go. And the people who are speaking today, you know, for substantive advice, you will have to pay, but everyone basically wants to help you to get to the next stage, you know. And sometimes the next stage involves investment of money, but sometimes it just involves asking a question or reading up on some information. So yes, I'm sorry about having to leave the room. We can invent a lot of things, but there's something we can't invent our way around, I'm afraid. So diolch yn fawr. So everybody, mae pawb wedi gorffan siarad. Everyone has finished speaking. Thank you. Diolch yn fawr iawn. Thank you to everybody. And I think, I hope although we've talked about dark arts and mystical things, I hope we've demystified it a bit. And that's certainly what we're intending to do, and look at the value of information that's there, whether it's IP information, and also trademark information. We haven't spoken much about trademark searching. I don't know if Joe wants to talk about that, but a lot of this information is already out there and available to you. Really, just remember that, okay, and learn to find it. So we've got to the stage now where if we'll be having discussion, but are there any questions that anyone wants to ask any particular speaker? So anyone should have a question in unrhyw. Anyone online want to ask the question with the magic of technology? Let's talk of magic today.
I've got a question.
Yes.
Yeah.
Oh,
I remember a case years ago
Yeah.
as well about Iceland, the company, against Iceland, the country. And I can't remember what the outcome was on that one. Does anybody know what the outcome was? Because I thought that was a bit ridiculous.
There's a lot of things that sound ridiculous. Joe, are you up to speed on this Iceland thing, or anybody else? I don't really know. So it's a bit unfair.
I think from memory, I think I blogged it. Sorry, Karen, Joe.
You know, I was going to suggest you comment, Jane. I'm not particularly familiar with it, but
It was quite recent, I think.
Yeah.
And I remember I was looking at it, and I probably blogged it.
Yeah.
But I don't think that I
think Iceland company would win that one.
Well, I can guarantee you that Iceland, the company's still here, and Iceland, the country's still here.
Still there, yeah.
So, yeah.
That's actually a good point as well. That that's people, you know, it sounds as if it's disaster, but actually the company's still here, the country's still here. And in a lot of these situations, you were talking about arbitration and things earlier. That goes back, I think, to what you said about arbitration. It isn't that one person defeats the other, destroys them utterly. A lot of these the solutions to these things that people learn to live with. They learn to make a bit of adjustment to. They learn to wind their neck in a bit. I think, hopefully, maybe Iceland, the country, wound their neck in a bit about, you know, what Iceland, the company, was doing. There's an awful lot of people testing the boundaries. If you ever go into Aldi, ever, right? they are a case in point of people who are walking that tightrope of, well, I don't know about that, but they do it.
Caterpillar, wasn't it?
They call it caterpillars and various things.
If you would like to comment on the Iceland case, I just looked it up. Yes, you are correct. Iceland, the country, tried to cancel Iceland Foods trademark registration on the basis that using the word Iceland as a trademark made it very difficult for Icelandic companies to sort of signal that their goods and services originate from Iceland. So they therefore argue that the term is generic, and it's still ongoing until July 2025, where the European Union's General Court affirmed a cancellation order on the mark. So that will I'm imagining that will go to the CJ, the European Court of Justice, at some point. That is what they're saying.
Okay, well, there was a question over there, and then I can see that Sandby is also asking a question, and it's about trademarks, I'm afraid, Joe.
Yeah, it's Kitan. It's just Kitan by something I can't seem to get rid of.
All right, okay. Well, there was just a question. Well, since you're on,
Yeah, no problem.
yeah. Would you mind? Do you want to ask a question sort of out loud, Kitan?
Should I ask out loud?
Yeah, please
Yeah,
do.
yeah,
do.
yeah.
I'm not sure everyone will see the chat.
Hi, Joe.
Hi.
Thank you for your presentation. I'm not too. I can't go into too many details, but I just wanted to understand your opinion on the trademarks that were cloned onto the UK IPO web database after UK left Europe, and I don't know how it works, but well, I do actually. I think I do. When a trademark examiner is examining the mark, your mark, and comparing it with other marks on the database, what do they not also look at your earlier historical marks? You know, the new mark is new, but do they not look at the previous historical marks for the same owner? And then that's my first question. And the second question is this question about earlier rights, because it's normally with trademarks, it's first to file, but also you need to provide use, you need to provide fair use, good use. But I've got maybe a situation where they're saying this cloned trademark onto the database has earlier rights for a certain area of technology, a certain area of service and product, but I actually have a registered trademark earlier than theirs, which uses the words they're saying I can't use as a in my newest application. So I suppose this third question is a bit more specific, so you don't need to answer that, but just what's your, I think it's too much of a grey area which needs to be sorted out.
Okay.
Yeah.
I was just going to say, I don't think we can get specific. I don't think that's fair.
Sorry I did that. I apologise.
It's like, send me an email, and I'll just outlining this specifically, and I'll discuss it directly with you. In a sort of free of charge initial call. That's perfectly fine, mate. Yeah. But yeah, other than that, it did seem like a sort of interesting question on use. I'm assuming it must be something to do with EU use versus UK use. I know that soon the 5-year period is running out on use in the EU, and we'll only be able to rely on UK use to support UK registrations, which will transfer over from Europe. So yeah, it sounds like it's something interesting we can explore with just the two of us in another call.
Yeah, sorry.
No problem, mate. Yeah.
And it's good you raised the issue of use, actually. I think that many people don't know that they have to have a history of use in order to keep a trademark alive and healthy and type of thing. And that if they don't, as you said, I think you said yourself, Joe, they're vulnerable to revocation if there is no use. And the jurisdictions, well, America in particular, are very, so top tip there. Keep evidence that you're using your trademark. And particularly now that everything's online, it used to be the case that you used to put leaflets and things in a folder and keep them in a drawer so that you could show, yes, I was, these, I've done this and I've sold it. But you need to just keep records that you're using your trademark, because one day you might have to prove it, and we will have to prove it at some point. So this
another top tip: put it on an invoice. Your early invoices, put your trademark on it. That's a really, really good example of use.
Yeah, because that's an easy thing to do. And this, when we talked about IP strategy before, IP strategy isn't all about I'm going to spend £10,000 on this and whatever. IP strategy is things like, and I'm going to put my copyright notice on everything I publish, and I'm going to put my trademark on my invoices, and I'm going to make sure that everyone I commission work from, there's some kind of arrangement as to who owns the intellectual property. And these things are tools of your IP strategy that you really need to. They're easy to do. They're like having insurance on your car or something like that. I mean, insurance on your house, maybe. They're not a statutory requirement, maybe, but they do help, you know, when the water comes through the ceiling. Anyway, you've been very patient.
All right.
Sorry, you had a question.
I've kind of got two. I had one originally, now I've got a second one for Joe. Well, everyone really. But in terms of trademarks and like using your trademarks, they put in stuff like leaflets and folders and stuff. Is using it all over your social medias and stuff enough to just sort of prove that you've been using it?
Absolutely. That's just simple answer. Yes, that's definitely use of trademark. That's marketing materials. Your I think it would be impossible to argue that that's not genuine use. There's got to be some sort of commercial advantage to promoting yourself on social media. So yes, definitely.
And then a complete flip round away from trademarks in terms of like patents and stuff. For somebody who is completely green to the whole process and everything, and if you think of a product and you think it's novel enough to get a patent on it, do you need to involve patent lawyers from the very start, or is it something that you can sort of do and file yourself?
I would recommend you're using a patent attorney because it's an expensive process. You've got to the drafting of claims, because that's what the invention is. Those are the numbered paragraphs at the end of the specification. They've got to be drawn up with great care. If you draw them too wide, then the patent's invalid. Or too narrowly, then your competitors can work around. And that's really what the patent attorney does, and that's his value. Obviously, he brings years of experience in technology. Most patent attorneys do specialise in particular technology, but they also bring, of course, lots of experience, such as what an examiner will let through and what he won't let through.
Yeah, I think initially, you have to draft the patent really broad to begin with, because you can't add subject matter in at a later date. So you want to claim as much as you can at the beginning, but you have to provide enough detail in there as well, so that you pass the sufficiency test, so that you actually are describing the invention sufficiently to enable somebody in that field to be able to carry it out. So I think where if you can actually file a patent yourself, there's nothing stopping you as an inventor, but you may not be able. You may then carry on and then start disclosing it to everybody, and then you go back and say, "Well, I've got a patent," but then it's so narrow because you just described.
Yeah.
When you first. If there is no budget at all, it's better to put something in there and get a filing date, I would say. But you shouldn't rely on.
Yeah. So if you have no budget for it, just could you do it and then just hope for the best kind of thing?
Yeah, but it depends, on the scope of it. For example, if you'd have come to me and said, let's say we're all sitting on the floor, you could say, I've just invented something called a chair, yeah, and then you said I've been working in my shed, and the optimum one is got like 4 legs because it's stable, it's got a backrest, armrest, make it comfortable. You may describe that in detail and file it at the patent office with 4 legs and everything. I would probably draft the claim saying a platform raised above the ground by at least 1 leg. Yeah, so that covers everything. So if somebody made it without the backrest, that's still within the scope of the patent.
Yes.
Yeah. Do you see what? So yeah.
Yeah.
And when you come to enforce it, it is the actual claim, the interpretation of the claim, which will either get you through, get you home, get the other side out of the market, or they'll say, well, sorry, this hasn't been infringed. So and that's why you do need patent attorneys. There was a time many years ago when members of the patent bar used to draft specifications, draft claims, That didn't happen in my time, but it has happened to people I've been in practice who I've come across. And I don't think that was ever a good idea because we just don't have a practical experience of working with the examiner in the way that you did.
No, yeah. So, I'm sorry.
Well, I was just going to give my sorry. I would say that it's a really dangerous strategy. Can you do it yourself? You can take out your own teeth. Can't you? I mean, I would do it. You know, you can build your own house without an architect, and but you know what you have to do if you wanted to do that? You have to learn a lot about building houses and architecture. If you want to do that, and it would probably be not as good and cost you more money in the end. And I think that's what would happen in patents. And the danger is the whole thing would fall down. I would, however, recommend, as I've said before, there's a lot of free training. The UK IPO's got some excellent free training resources for people on IP. I can't even remember the name of the brilliant course they used to do. IP Masterclass. Yeah, but there's loads. They've got different ones aimed at different people. IP tutor, depending whether you're a student.
Emma might know. Emma might know.
Emma's there. But there's some excellent IP resources. So if you're going to, I would do that. That's free, right? Do it. Learn about that. This is free stuff. So that at least you know what you're talking about. A bit like when you're talking to the architect. If you know what they mean by planning permission or whatever, it's going to expedite matters and you're going to have a better conversation. But don't think that means you can do it yourself. Hi, Emma.
Hello. I'm happy to input here if it's helpful. Yes, there's lots of information and resources on our website. There's lots of training videos. We've actually put a new package together now, which goes through the life cycle of an IP, right? So it's kind of a step-by-step guide for businesses, individuals, SMEs who are thinking about IP, but take advantage of all of the resources available on our website because like Nia said, it's free. There is an IP masterclass that you can attend as a commercial business. Well, there is a cost for that though, but it's a 2-day in-person event and it's £300 or around that kind of mark. So yeah, if you are interested in attending any kind of training or getting some further information, I'm sure that we'll be happy to send that out to you.
So Emma is the voice of the IPO in this.
All right.
But actually, Emma, if you could send them links or a page or something like that, so that we could provide that to people with the IP resources from the IPO, which I keep bigging up to people, but don't have a link to. So that's pretty useless.
Yeah, no problem.
That'll be really helpful.
I mean, and if you're trying to find it yourself, just a little tip: the easiest way to search for things on our website is to into a search engine, type IPO first, and then the resource you're looking for. Because what you need to be getting it from is the Gov website. If you click on home on the website, once you get there, it will take you back to gov.uk home. So it'll give you options of HMRC and all the other government departments. So the easiest things on our website is to type in IPO first and then resources, country guides, trademark search facility, which again is a good tool to use as a bit of due diligence to give you an idea of the trademarks that are currently protected before you apply for trademarks yourself. Again, another free service that is available for you to use. So there's lots there. There's lots out. So to do a bit of research yourself and give us a call as well. We've got advisors on the other end of the line who are not a switchboard. They're very knowledgeable about IP and they're quite happy to have a conversation with you about your worries or concerns.
Oh, thank you so much. I think that's another good point. There's a lot of information online, but make sure it's from, number one, make sure it's from the UK or whatever jurisdiction you're looking at, because the law is different in different countries. And in my experience, the internet's full of stuff about America, which really it's not relevant here. So don't, if you think, if you want to know something, make sure it covers the right jurisdiction and it's from either something like the IPO or from a reputable patent firm who often put out they put out information booklets and things on various cases and stuff, and those things can be very, very informative and useful. Anyway,
Where's me for a second? I need to get the translator out of that room because there's another meeting there. If you don't stop it, that's on the strap.
Yeah, I was just going to add to what you said, Nia, in response to the earlier question about doing it yourself and how, you know, these IP rights sort of extend from your own jurisdiction to another where the law's slightly different and stuff like that. And, you know, you can end up with a situation where you filed a mark and it gets licensed in one place and sold in another place. It's filed several different times in several different jurisdictions. The specification slightly changes. And if you are sort of confronted with a dispute or someone is trying to take advantage of your rights, they'll do everything they can to make the way every little one of those stages is done a headache for you. So, like, you know, they'll say this wasn't properly licensed, it wasn't recorded at this IPO, the specification at the filing date wasn't the same as it was now. Did you use it in that country at a particular time? So it sort of can, if there are issues made at outset, they can sort of compound as your business grows and things go on. So that's the only sort of input I had on sort of doing it yourself. Trademarks is definitely more plausible to do it yourself than patents, and you'll probably get a slightly stronger right, but yeah, as time goes on, the sort of cracks can start to open a bit more.
I still recommend going to a trademark attorney.
Yeah, this one.
Oh, I mean, there are lots and lots of businesses which are set up to say, well, they can give a registered trademark at discounted rates or very quickly or whatever. And one or two of them will do that. From a law firms, every single law firm I come across seems to claim to be able to register trademarks. It isn't easy. You've got to make sure that the specification is right. You've got to ask the right questions. How do you see your business in whenever it is, so many years' time? Because that will be key to whether you're going to register a particular good or service in that particular class. The scattergun approach, registering everything, means, first of all, the poor old client has to pay a great deal more because more classes and more goods that he registers, more he has to pay by way of office fees. And secondly, they can get it. They can just apply for so many things that if there is a challenge, well, they'll lose it at the first challenge in front of a hearing officer or in front of a judge.
Oh.
So it is important, I think, to use guys like you and for patents, guys like Sean. You do keep you. I think you earn your keep pretty well.
That's a nice note to end on.
Yeah,
And we
thank
brought this exactly. So I can only thank all the speakers. Thank you so much for speaking, whether online or in the room. Thank you so much to Ian for organising. I didn't thank you at the beginning, Gwen. What an ungracious person I am. And thank you everybody here for your patience in attending. I hope you've learned something, and I hope you've learned that there's more to learn and that there are people out there waiting to tell you about it. So, diolch yn fawr iawn I bawb. Thank you very much, everybody.
Thank you.
It's a very big thank you to Nia for chairing today as well. You've been so fantastic as usual.
Thank you.
Thanks, yeah.
Thank you.
Thanks.
Bye, everyone. Thank you.
Good job.
Bye, Sean. See ya.
We should have said that Mr. Harrison, who's partner for trademarks, is also your partner for patents.
Yeah.
He used to be the